Right, guys, a bit more information has dropped on the Alex Salmond and Nicola Sturgeon situation. That involves most of the SNP that support her and even helped her take part in the witch hunt against him. Now, Craig Murray's evidence I went through a week or so ago proved to me that Nicola Sturgeon, or at least those around her, including her husband, actively worked to take Alex Salmond down, possibly because they feared he would return to the party and take over or something. Either way, the SNP's actions around this seem very paranoid and desperate if you ask me. Now, personally, I don't like Alex Salmond in the slightest and never have, but something I despise more is corrupt scumbags trying to ruin someone's life for their political gain. And even more so when these scumbags are actively destroying a part of the country. All union supporting feelings aside, the SNP are sending Scotland into the shitter. It is literally the drug death capital of the world, hospitals of poisoned kids and all sorts of shit like that. Add that to the most delusional sense of independence I have ever heard and you get the SNP. It is actually an embarrassment to Scotland and independent supporting parties in general, let's be honest. But Alex Salmond has now helped destroy any credibility the SNP and those around Sturgeon might have had in relation to their witch hunt. In fact, I would call it outright corruption at this point. It is pretty clear now, with multiple people saying the same thing, that this witch hunt was designed to take him down at all costs, using some blatantly shady tactics to do it. I mean, they literally changed the rules to help them get him, as they say, but still cocked it up royally, as you would expect. Now, his submission to the committee investigating this is pretty short and was released yesterday. It only contains about 10 pages of information that we need to go through. Now, I will read through the entire thing. Hopefully, it won't take too long. It says written submission from Alex Salmond. Number 1. The Permanent Secretary wrote to me on the 7th of March 2018 saying that the Scottish Government was implementing a complaints process against me. I instructed Libya McRae as my solicitors and Ronnie Clancy QC and Duncan Hamilton Advocate as my counsel. At an early stage, it was clear to me and my legal advisors that the process was defective in a number of ways and that the application was suspect. In particular, I had never heard of any such procedure applying to former ministers and there was no parliamentary or public record of it ever being implemented. So there he is laying the groundwork for them actually coming out and trying to do something that has never been done before, obviously showing that it's a bit of a witch hunt. Number 2. One striking and immediately identified feature of this policy was that there was no provision for mediation in the case of former ministers, in contrast to the policy on Serbian ministers, see paragraph procedure 4. I put this to the First Minister at the meeting at her home on the 2nd of April, which has now been referred to on many occasions. Yeah, because she tried to deny it. Such a provision would be a formal feature of complaints policy and was specifically part of the Scottish Government's policy, which I was familiar. There, once again reaffirming the fact that this just seems like a blatant attempt to take him down. Number 3. In the meeting of April 2nd, the First Minister had suggested that she would intervene in favour of mediation process at an appropriate stage. She subsequently decided against such an intervention. In the event, our proposals of the 4th of April 2018 seeking mediation were rejected by the Permanent Secretary without them even being placed before the complainers as an option. Number 4. My legal team crystallised our objections to the procedure in a letter to the Permanent Secretary on the 5th of June 2018. This letter, which has been provided to the committee, gives senior counsel opinions that on grounds of retrospectivity, absence of jurisdiction, and multiple examples of lack of procedural fairness, the procedure was inherently flawed and unlawful. A summary of the legal arguments is also provided in the open record which we have provided to assist the committee. However, to this and to other representations on procedural unfairness, there was no substantive response. Number 5. My legal team advised strongly against rebutting specific allegations because, in their view, the government had pursued an unfair and unlawful process. Their advice was that in those circumstances, full engagement and detailed rebuttal, as ultimately was provided in the High Court, would risk being presented as having acquiesced in that unlawful procedure, however, agreed to using independent witness statements to refute general allegations. I have produced for the committee the full correspondence from the 7th of March 2018 up to the date of raising procedures which should be read in conjunction with this submission. Number 7. No substantive reply being received to our legal arguments, my lawyer advised that I should move to judicially review the government and that the prospects of success were excellent. I had asked them to draw up a draft petition for judicial review, but I was extremely reluctant to sue the government I had previously led. I was also deeply concerned about such an action given what it might mean for both the First Minister and the SNP. I therefore asked to meet the First Minister to show her a draft judicial review petition. This meeting took place on the 7th of June, I'm assuming 2018. In contrast to our first meeting, the First Minister was now against making any intervention, although I had previously spelt out in a WhatsApp message to her of the 3rd of June what I considered to be her duty to do so under the Ministerial Code. That too has been provided to the committee. Number 8. On the 26th of June 2018, still seeking to avoid damaging court proceedings, we, my legal team and I, put forward a new proposal for arbitration drawing on Scottish legislation passed in 2010. The offer was that I abide by the decision of the arbiter if it went against me. We were confident that many of our criticisms would be accepted in any arbitration and agreed to submit to full Scottish Government process if my legal advice was wrong. Arbitration had multiple advantages. First, it was confidential and thus protected those who had made the complaints. Secondly, it would provide legal clarity and resolve whether the clear advice on the unlawfulness of the procedure was correct. Thirdly, it would have resolved these matters in a forum which maximised the potential for avoiding expense to the public purse, to me, and minimised the damage in fallout to the complainers, Scottish Government and the SNP in the event I was successful. I explained the benefits of arbitration to the First Minister in a WhatsApp message of July 5th. At the First Minister's invitation, delivered by a senior official on July 13th, I met her for a third time at her home in Glasgow the following day to ask her to make it clear that she was not personally against such arbitration. That request arose in case any such perception was the basis for the otherwise inexplicable decision on the part of the Permanent Secretary to refuse any form of alternative dispute resolution, and instead force this matter into an expensive judicial review in the Court of Session. I updated my lawyers about this meeting. Number 9. On July 18th, I was written to by the Permanent Secretary and phoned by the First Minister at 13:05 urging me to submit evidence on the specific complaints. This I did after a formal consultation with my legal team to whom I divulged the First Minister's phone call and advice. I refer to my submission made to Mr. James Hamilton, the independent advisor to the Ministerial Code, which covers this passage of my evidence. Number 10. I know that the submission was given only the most cursory examination by the investigating officer whose report had already been drafted and submitted to the Permanent Secretary. The rebuttal was submitted on Friday, July 20th. The investigating officer finalised her report after submitting my comments to both complainers on Monday, July 23rd. On August 22nd, the Permanent Secretary sent me her decision report, having already instructed that it be sent to the Crown Agent, Mr. David Harvey, not bringing matters directly to the attention of the police as provided for in the policy. On August 21st, the Chief Constable and the lead officer correctly refused to accept the decision report when the Crown Agent tried to hand it to them and asked them that there be no publicity, lest their investigation be contaminated. Which I have to say on that piece there, wow, that's pretty damning there. The Chief Constable and lead officer correctly refused to accept the decision, showing obviously that it was unlawful and they didn't want any part of it. It really makes you wonder how the SNP was able to get away with this or think that they would. Number 12 though. Despite this, on Thursday the 23rd of August, my legal team was informed that the Scottish Government intended to release a public statement on the fact of the investigation at 5 p.m. that day. That, despite the firm assurances of confidentiality which had been made throughout, we replied that such a decision to publicise left no option but to seek an interim interdict against the government that evening preventing publication. That action became the petition for judicial review, which is what we're talking about here. The Scottish Government agreed to withdraw their proposed public statement pending resolution of the interim interdict application by the Court of Session. By late afternoon, the government claimed that they had been contacted by the press but had confirmed nothing. At 6:34 p.m, we informed the government that an interim interdict would not be heard that evening. We had by that stage had no contact from any news outlet. Shortly after 8 p.m, I was phoned by David Clegg, political editor of the Daily Record, who then emailed me at 2016 informing me that he had now been given confirmation that a police complaint had been made against me, and were publishing their story at 10 p.m. We were unable by that time to secure a judge to hear an interdict against the Daily Record's proposed story. At 9:30 p.m, through my lawyers, I sent a statement embargoed until 10 p.m, explaining that I would be raising proceedings against the government and calling a press conference for the next day. The press statement reads as follows. Statement from Alex Salmond, embargo 10 p.m, Thursday the 23rd of August. Former First Minister takes legal action against Scottish Government in Court of Session. For many months now, on the advice of senior counsel, I have attempted to persuade the Permanent Secretary to the Scottish Government that she is behaving unlawfully in the application of a complaints procedure, introduced by her more than 3 years after I left office. This is a procedure so unjust that even now I've not been allowed to see and therefore properly challenge the case against me. I have not been allowed to see the evidence. I have tried everything, including offers of conciliation, mediation, and legal arbitration, to resolve these matters both properly and amicably. They would have been in everybody's interest, particularly those of the two complainants. All of those efforts have been rejected. The Permanent Secretary chose to deny me contact with any civil servant, many of whom wished to give evidence on my behalf, and access to documentation to allow me to properly challenge the complaints, all of which I refute, and some of which were patently ridiculous. The procedure, as put into operation by the Permanent Secretary, is grossly unfair and therefore inevitably will lead to prejudicial outcomes. It is therefore with great reluctance that I have today, Tuesday the 23rd of August, launched a judicial review in the Court of Session which will decide the issues of the lawfulness of the procedure which has been used against me. If I lose, then I will have to answer to the complainants both comprehensively and publicly. Until then, I am bound to say nothing which would impinge on the court proceedings. In our submissions on the judicial review, we have asked that the complainant's identity be protected. If the Court of Session finds in my favour, then the administration at the senior levels of Scottish Government will have the most serious questions to answer. In my opinion, and for whatever reason, the Permanent Secretary has decided to mount a process against me using an unlawful procedure which she has herself introduced. I will let a real court decide whether it is lawful for her to do so. Of course, it's obviously not. You can see the SNP's arsehole puckering up tighter than a snare drum as we speak. And actually, it has been doing it for a good few weeks now. But now back to his actual evidence from this time around, number 14. The press conference was held on August 24th and was entirely devoted to the process of judicial review, with no discussion allowed on the nature of the complaints. However, the Daily Record has also been leaked the detail of one of the complaints taken directly from the Permanent Secretary's decision report, or an extract from it, and published those details on August 25th. The Daily Record editor later confirmed on a documentary presented by Kirsty Walk on BBC television on the 17th of August 2020 that he had been in receipt of such a document. Something that was also mentioned in Craig Murray's evidence before. But if you haven't seen that video on Craig Murray's evidence, then I suggest you go and watch it. It is extremely relevant to what is going on in this one. Number 15. The timing of these leaks is summarised in the enclosed review report from the ICO, who concluded that they had sympathy with the hypothesis that the leak come from an employee of the SG and agreed that the timing could raise such an inference. There were in fact two leaks. First, the leak to Mr. Clegg on the evening of the 23rd of August, followed by the release of details of one of the complaints published in the record on Saturday, August 25th. These leaks were carried out with no consideration to data protection laws and with no regards to the interest or rights of the complainers or indeed myself. They were considered by the ICO to be prima facie criminal. They set off a media storm deeply damaging to my reputation, which was obviously their aim, and it would appear the entire aim of the SNP shitweasels that were taking part in this. Number 16. On the 29th of August, I resigned from the SNP and launched a crowdfunder to assist with the cost of judicial review challenge in the Court of Session. The crowdfunder attracted 4,146 donations in 3 days, and I closed it at £100,000 on Saturday the 1st of September. Number 17. Shortly after, my legal team lodged a petition for judicial review. Their advice was that the chances of success were high. The initial petition has been provided to the committee. The Permanent Secretary has made much of the fact that the original petition for judicial review did not found on the prior contact of the investigating officers with the complainers. In fact, this would have been impossible given that the information was not provided until the beginning of November 2018. Indeed, there is overwhelming evidence that this information was concealed by the Scottish Government. Had it been provided earlier, it would certainly have been included in a further basis for the judicial review. Even without it, there were multiple substantial grounds for a successful review. Those were not decided simply because the Scottish Government conceded the petition prior to the matter being argued. Number 18. On the 4th of October, at the first hearing, my legal team lodged a motion to protect the anonymity of the complainers. The Scottish Government chose not to attend this hearing. Number 19. On the 16th of October, the Scottish Government lodged answers to the judicial review, which lent heavily on a technical argument that the petition was at a time being more than 3 months after the investigation started. We were not concerned that there was any force to that argument, and I personally took that as a sign of weakness and a lack of confidence in their substantive case. That argument was later abandoned, obviously. Number 20. On the 21st of October, we received information that the new complaints process had not been published on the internal Scottish Government intranet until February 2018, which opened the question of how realistically complaints could have possibly been submitted under it in January 2018. We also learned that the press statement released by the Permanent Secretary on August 23, 2018 had been deliberately worded to conceal this fact. It says Appendix B shows the original wording and Appendix C the version as recently amended on the 21st of August 2020. The original wording reads Internal Procedure agreed in December 2017 and published at the time on the Scottish Government intranet. The new wording reads Internal Procedure agreed in December 2017 and published in February 2018 on the Scottish Government internet. Our requests for further documents were informed by those revelations. Showing, of course, once again, people in the SNP are at least blatantly lying there, and not only lying that, they're lying to committees and judicial reviews. This is pretty fucking incredible. On November the 5th, the government finally disclosed their prior contact of the investigating officer with the complainers and that both complainers had been in contact with various Scottish Government staff in November and December 2017. As we know, this was only after Senior Counsel insisted that they do so. We adjusted the petition accordingly. Number 22. On November 6, we petitioned the court for release of documents. Lord Pental reminded the government of their duty of candour as a public authority to release all relevant material, saying, according to a court note taken by my legal team, that a public authority usually takes the view that it should disclose everything in a matter of this nature. Specifications are unusual for that reason. Unless, of course, you're corrupt and trying to cover up said corruption. But why does this not surprise me in the slightest? Number 23. Despite this, on the 16th of November, when the first tranche of 147 documents were produced, followed by a further 70 pages on the 19th of November, it was clear that much information was missing, particularly on the origins of the procedure. During November 2018, we became concerned about the possibility of the government attempting to delay the judicial review and, mindful of their likely loss in court, seek to emphasise instead the police investigation. We have a witness precognition statement which recounts that in late November 2018, a special advisor told a witness that the government knew they would lose the JR, but that they would get him in the criminal case. As I said earlier, they literally said that they would get him. They are being quoted there as what they have said. All pretty damning so far, especially when you add it in to the other evidence that has been given alongside this. Craig Murray is just one of those at the moment. Number 25. On the 1st of December, the ICO Criminal Investigation Officer informed us that a criminal offence may have been committed on the leak of data and that their investigations were continuing. Number 26. On December 14th, we successfully petitioned for a commission on diligence. It was opposed by the government, who had maintained that no more relevant documents existed. Remarkably, the Scottish Government had even signed a certificate confirming to the court that no documents existed, in direct contradiction of that position in the immediate run-up to the commission, during the commission itself, and in the aftermath of it. Many batches of documents were produced which exposed many incriminating pieces of evidence against the government's position, because obviously they've been talking a bag of shit. This goes without saying at this point. Furthermore, it became clear that the government's position until that point on the nature of the contact between the investigating officer and the complainers was untrue. We also were aware that the government's position introduced into their pleadings for the first time the First Minister knew of the complaints against me on April 2nd, 2018 was also untrue. Something that the media have picked up on, but they ain't picked up on the rest of it. I wonder why, the corrupt bunch of shitweasels. Realistically, much of what he is saying here should be front page and headline news on most media outlets. I mean, let's be honest here, most of what he is saying in this submission and the other ones that I have covered before now should really be front page news. The BBC, Sky News and that should be all over it like a rash. Of course they're not, they're too busy promoting bullshit, and we all know they kinda love the SNP, especially Nicola Fishlips Sturgeon. But the fact that the Scottish Government actually signed a certificate confirming they had no documents when they blatantly did really makes me laugh. Imagine actually thinking you can get away with half of the shit that they have. Perhaps they literally thought because they're the Scottish Government they can use their power to cover it all up. Unfortunately, it doesn't look like that's worked out well, and in fact could probably put them in more shit than originally if it would have just come out. Number 27. On the 19th of December, at the first hearing of the Commission, the government's own senior counsel apologised to the Commission on multiple occasions for the late provision of documents. A further 18 pages of documents were then produced from the investigating officer. More documents emerged after the second hearing of the Commission on the 21st of December. In a further procedural meeting of the Commission on the 28th of December, it emerged that potentially many more documents existed. My legal team then decided to call Chief of Staff Liz Lloyd and Principal Private Secretary Miss Somers to the Commission as potential havers. At the beginning of January 2019, this was when the suggestions emerged of meetings with a complainer in the First Minister's office on the 20th and 21st of November 2017. Once again proving that they lied and possibly conspired with the complainers to try and get more done, even going against what they have said which has been suggested. Number 28. On January the 3rd, my lawyers were contacted by government lawyers with an offer to concede the case on the basis that the process had been unlawful, unfair and tainted by apparent bias. Because obviously the SNP couldn't keep up the bullshit charade anymore. Number 29. On January 8, 2019, Lord Pentland, after hearing in the Court of Session, issued an interlocutor to that effect and reduced both the investigation and Permanent Secretary decision report. The government provided undertakings not to distribute documents. Those undertakings were recorded in the minute of proceedings. Expenses were awarded on the punitive scale of agent and client paying basis. The interlocutor found that the actions of the Permanent Secretary had been unlawful on the grounds that the process had been carried forward in the circumstances were procedurally unfair and tainted by apparent bias. My senior counsel pointed out in the court that the investigating officer's multiple contacts with the complainers were bordering on encouragement. Which, yeah, I would say that is a very charitable thing to say there. It is very possible that that is exactly what was happening. Of course, we don't know for sure. Number 30. On the same day, the Permanent Secretary released a press statement asserting that on all other grounds the petition had been dismissed. This was deliberately misleading, as in fact none of the many grounds of the challenge required to be heard. This was deliberately misleading, as in fact none of the many other grounds of challenge required to be heard, since the petition had been conceded prior to the hearing and a whole decision report reduced by the court. My legal team and I remained confident on many other legal heads of challenge that I had brought. They are all contained in the record court document containing petition and answers, which the committee has. So there we see, as expected, the SNP are pulling out a good little bit of spin. Why does that not surprise me in the slightest? It's a bit like the government down here, actually, full of spin and absolute bullshit. Though either fortunately or unfortunately, the government down here hasn't been caught out for this level of corruption. Number 31. The First Minister told Parliament that the nature of the contact between the investigating officer and complainers was in the nature of welfare support. Clearly, she was misinformed, because it is precisely because the government had misled the court in its proceedings about the nature of the contact that the government's case became, in the view of their own counsel, unstateable. This was confirmed to the committee by Lord Advocate in both of his evidence sessions on the 8th of September and the 17th of November 2020. Number 32. At no stage was I, or indeed Parliament, informed of the fact that both senior and junior counsels representing the government had intimated in December 2018 their intent to resign from the case if the government did not concede by January 3rd, 2019. Which is obviously a rather damning thing to be put on the government there. How the hell can the SNP worm out of that one? If your own council's ready to step down because they don't trust what you are fucking doing, then that says a lot really, don't it? Of course, this is the SNP. I'm sure they actually don't give a fuck. Number 33. I am now aware from documents obtained by this committee that the investigating officer's behaviour involved contact with complainers before, during and after the procedure of a kind which would not stand any reasonable test of impartiality. I believe this included briefing the complainers and witnesses on pejoratively summarising my legal advice. I also understand that subsequent to the JR petition being lodged, she also briefed complainers and others of the Lord Advocate's position on assisting the judicial review. Number 34. I am now aware from documents recently obtained by this committee that the Permanent Secretary met one complainer and phoned the other in mid-process before contacting me on March 7th, 2018. I was astonished when I discovered this. To be honest with you, I'm pretty astonished by almost everything you've said in this report so far, and we are very near the end. This is the last point, and then we have a quick summary which I will read through. But this whole thing here, if you ask me, is a complete clusterfuck on the SNP and Scottish Government in general. He goes on, there is nothing in the procedure which allows for this, and I would certainly have wanted to argue this in our judicial review petition, as behaviour incompatible with the role of an impartial decision maker and further evidence of bias against me. The failure to disclose this meeting, either in the civil or criminal case despite court orders, is a serious matter which I intend to take forward with the appropriate authorities. Meaning, obviously, this shit show is not over here. He is going scorched earth and is going to take these motherfuckers down. I actually can't wait. Like I said, I don't particularly like him, but I dislike Nicola Sturgeon also, and by the sounds of it, she's a right corrupt cunt, as is everyone around her, making her even more of a shitweasel than Alex Salmond here. Now, here we have the quick summary, which I will also read before I end this video. It's already far too long as it is. It says, summary, the procedure adopted at Pace in late 2017 was not just tainted by apparent bias in the actions of the investigating officer, but procedurally unfair in itself. Only my reluctance to sue the government as a former First Minister prevented me from exercising that right earlier. Instead, I offered conciliation, mediation, and then arbitration, which I was prepared to accept as binding. All such attempts at swift and confidential resolution of the legal issues without the expense and confrontation of court proceedings were rejected without consulting the complainers, in case of mediation without initially consulting the complainers, and in the case of arbitration without consulting the complainers at all. There is an overwhelming likelihood, in my view, that the criminal leaks of August 21st and 22nd came from within the government and were committed with the intention of damaging my reputation, but with no regard whatsoever to the interest of the complainers. The advice of my counsel at the outset was that I had a very strong case, which only further strengthened as the process continued. The evidence was forced out of the government by a lengthy and expensive commission process, despite the government having assured the court and my legal team previously that they had produced all relevant documents. This turned out to be untrue. I have yet to read the government's legal advice from external counsel. This is despite 2 parliamentary votes to force its release. It is rare in my experience for the Scottish Government to behave unlawfully. It is surely rarer still for the government to only concede a case when both of external counsels threaten to resign. I understand that expenses being awarded on an agent and client paying basis reflects the court's dissatisfaction with the conduct of the case from the government. That failure was not just due to incompetence. The pattern of government lack of candour and a systemic failure to disclose has been deliberate and consistent since March 2018. It continued through the JR process and my criminal trial. To my astonishment, it continues to this date, with a persistent failure to produce all relevant documents to the parliamentary inquiry, which has forced 2 parliamentary votes and triggered an unprecedented procedure under Section 23 of the Scotland Act. It has also seen the recall of a number of government witnesses to clarify and in some cases correct their evidence. In short, it remains a matter of deep regret that I had no option but to take the Scottish Government to the Court of Session. I did so very reluctantly and only after every other avenue had been exhausted. But courts exist for a reason. They exist because when governments act illegally, there must be remedy for the citizens. In this case, the illegality was finally conceded, but only after a legal process which would have cost upwards of £750,000 of taxpayers' money and which caused immense strain and distress to all involved. The behaviour of the government was in my view a disgrace, but actions have consequences. Accountability is at the heart of the Scottish Parliament. The rule of law requires that those who have acted illegally are held to account. It is now the job of this committee to resolve how that is best done. Signed, Alex Salmond, the 27th of January 2021. Now, sorry guys, I actually read that whole thing out to you. It's fucking massively long and completely boring to most people, but some of the information in there is rather important. I really don't know how anyone can see that the SNP are not neck deep in some serious corruption here and blatantly lying to multiple bodies consistently. Of course, I still think Nicola Sturgeon is the Teflon Don who will just brush this off and carry on regardless. We will have to wait and see. There is certainly more to come from this, and hopefully people are gonna start being arrested. I still, like I said though, remain skeptical that anything will come of it. We can obviously hope though.
There is a pattern consistent throughout history of oppressed people turning on the oppressors, slaves against their owners, the peasantry against the feudal barons, colonies, Mr. Verhofstadt, against their empires, and that is why Britain is leaving. And it doesn't matter which language you use, we are going, and we are glad to be going. We're off.